Pulitzer Prize winning journalist Linda Greenhouse has covered the Supreme Court for the New York Times for the past 40 years. From her behind-the-scenes view, she has witnessed many pivotal moments and monumental decisions, but none more so than the 2020-2021 term. Her new book, Justice on the Brink, is a month-by-month narrative of a year marked by the death of Ruth Bader Ginsburg, the confirmation of Amy Coney Barrett, a global pandemic, and a much-contested presidential election. Justice on the Brink offers the astute observations on the Supreme Court's inner dynamics that have made Linda Greenhouse our most respected reporter on our highest court. For today's conversation, Linda Greenhouse is joined in conversation by Missouri Supreme Court Justice Mary R. Russell. A native of Hannibal, Missouri, Justice Russell previously served as a Missouri Court of Appeals justice and has been a state Supreme Court justice since 2004. Copies of Linda Greenhouse's Justice on the Brink are available for purchase from St. Louis independent bookseller Left Bank Books.
Hello, my name is Mary Russell, and I'm a member of the Supreme Court of Missouri. And I'm happy today to be in conversation with Linda Greenhouse, a Pulitzer Prize winner who has written a new book called Justice on the Brink. The subtitle, The Death of Ruth Bader Ginsburg and the Rise of Amy Coney Barrett, and the 12 months that transformed the Supreme Court. It's nice to meet you, Linda.
Oh, it's a pleasure. It's really a treat for me to be here and to chat with you.
Thank you. I so enjoyed reading your book. You know, I was so impressed with how you could take a complex case or complex legalese, complex Supreme Court opinions, many times in which there's more than one opinion, and make it easy to understand for everybody, regardless of whether or not you had a law degree. And I know you yourself don't have a 3-year law degree. And so I'm just curious, how have you been able to develop this deep understanding and this ability to write on such a level that anyone can understand and appreciate this book?
The book is a chronicle, a month-by-month chronicle of the last term of the Supreme Court, the term with the 3 justices appointed by President Trump. The book starts in July of 2020. And it finishes when the last term finished in July of this past summer. When people ask me how long it took to write this book, my answer is 7 months and 40 years. And what I mean by that is, for 30 years, I was the New York Times Supreme Court correspondent, which meant that I went to the Supreme Court every day. I had a desk in the Supreme Court press room. My job was to translate the work of the Supreme Court into ordinary English that a New York Times reader could understand. And by New York Times reader, the reader I had in mind was really myself. Before I had a chance to spend a year at Yale Law School, where I got a master's degree, not, as you pointed out, a 3-year law degree, but I had some education and then spent all these years writing about the court. So before all that happened, I would have just been an ordinary New York Times reader with some curiosity. I didn't need to be spoon-fed. I needed to be met at a level of certain sophistication, but I needed to be addressed in plain English. And so I think that's what accounts for what you observed about the book.
So since you've had 40 years of covering the Supreme Court, you're very familiar with the personalities that work there, with the procedures, and you've seen lots of changes in the composition of the court. You point out in your book, when Justice O'Connor left the court, she was considered more of a centrist, and she was replaced by Justice Alito, who is considered by some to be more of a conservative. So that was a big change in dynamics in the court. So what inspired you to write about this particular term?
Well, of course, something very sad and very dramatic happened just on the eve of the 2020 term starting. And that was the death of Justice Ginsburg. She died on September 18th. Supreme Court term starts on the first Monday of October. We had an election underway. Even some people in different parts of the country had availed themselves of early voting. The election was really underway. Mitch McConnell, Republican leader of the Senate, said, we're going to fill this seat. And as I recount in the book, he called the night that Justice Ginsburg died, he reached President Trump, who was on Air Force One flying back from a campaign appearance. And Senator McConnell said to President Trump, you're going to fill this seat and you're going to fill it with Amy Coney Barrett. So this was an amazing sequence of events. I mean, the president nominated then Judge Barrett before Justice Ginsburg had even been buried. So something really dramatic was going to happen that year. And it was going to make for a tale to tell.
You talk about the fact that whenever there's changes in composition in the court, there really shouldn't be a change in the precedents in the law. But you give examples in your book where you think that with the death of Justice Ginsburg and the appointment of Justice Barrett, that maybe some precedents has shifted. Can you give us some examples today, or even one example of where precedents has changed because of this change in composition on the court?
People might have heard a bit about the so-called shadow docket. What does that phrase mean? Shadow docket means cases that come to the court on an emergency basis. Somebody's come to the court and said, we need help right now. We don't have time to go through the whole procedure of argument and, full briefing and so on. So it was really in the shadow docket that things started changing in the context of the COVID pandemic. So as people know, all across the country, various governments, state government, local government, were imposing limitations on the number of people who could gather in various kinds of venues, including venues for worship. So cases came up in the spring of 2020, when Justice Ginsburg was still alive, from churches and other religious entities saying that these restrictions on how many people can gather for worship violate the free exercise guarantee of the First Amendment, because you're letting people go to the shopping mall, but you're not letting everybody we want to let into our church service come in. So there were a couple of these in that spring and early summer, and these challenges were rejected by the Supreme Court on the shadow docket by votes of 5-4. Chief Justice Roberts, Justice Breyer, Justice Ginsburg, Sonia Sotomayor, and Elena Kagan rejected the religious challenges. Then, of course, Justice Ginsburg died. New challenges came. Amy Coney Barrett was sitting where Justice Ginsburg had sat, and by votes of 5-4, the cases came out the other way. This happened within weeks of Justice Barrett taking her seat, actually on Thanksgiving Eve of last year, and it was very dramatic and kind of set the stage for what we know are going to be other changes to come.
The 2021 docket, you indicate, was largely filled with religion cases. And as you somewhat alluded to already, it appeared that the court was starting to analyze these religion cases in a different manner, starting to look at safeguarding indoor worship as opposed to protecting public health concerns during the pandemic. Do you think the court is turning the freedom of religion right into a super right?
Oh, I think so. I mean, the kind of jargon that people use and that I refer to in the book, religion now has a quote, I'm putting this in quotes, a most favored nation status. What does that mean? That means that if any comparable activity is treated better than any religious activity, comparable religious activity, that restriction on religious activity is unconstitutional. Now, that's something quite new. And of course, the word comparable is a very expansive word and carries a lot of weight. So I'll give you one example of one of these shadow docket cases, the most important one, I think, a case from California, a case called Tandon against Newsom. So this was a restriction on the number of people who could gather in a private home. It was limited to 3 unrelated couples for any purpose, for a dinner party, birthday party or for home worship. So two individuals who conducted worship services and Bible reading in their homes challenged this, and they said, you're letting people go to the shopping mall and you're not letting people inside the home for religion, and that's unconstitutional. The lower court, the district court in California and the Ninth Circuit Court of Appeals said, wait a minute, you're treating religion exactly the same. They can't gather in the home for a party and they can't gather in the home for worship. There's no discrimination. There's no distinction. There's no problem. The Supreme Court saw it differently. They said, well, you're letting people gather elsewhere, but you're not letting them gather in the home for worship. They just kind of wiped away the difference between home, where the government didn't want people to spend long periods of time in close quarters, where there really could be no regulation, no knowledge about the air circulation, any of the things that we've come to be aware of during these months of the pandemic, and somebody breezing through a grocery store to pick up a quart of milk. Just two different ways of looking at it. It was 5-4. And I think that really established the primacy of a religious claim above all other claims. And that's not actually the world that we have been living in until this year.
Well, historically, there's always been a swing vote on the court. Justice Powell, Justice O'Connor, Justice Kennedy, and more recently, Chief Justice Roberts for a period of time. But you indicate now that after this last term has been completed, that you write about, that there appears to be maybe no swing vote. How does that impact court decisions?
The court the other day heard the first of the abortion cases that is going to hear this term on the Texas, what I call the vigilante law, the law that's basically shut down abortion. In the state of Texas, the case the court heard didn't go to the essence of the actual right to abortion, but had to do with, can challenges be brought? Can federal courts be open to challenges to this law brought either by the individual abortion providers in Texas or by the federal government? And it was possible to see, it's always dangerous to extrapolate from the comments that justices or judges make on the bench in the course of oral argument, but people were sort of laying down their markers pretty openly in this argument, which went on for 3 hours, and that's a long time for a Supreme Court argument. There were different coalitions, and it certainly seemed that the 6, let's say, conservative justices, I'll use that word, were not at all united on how to approach this question. And you could see a 3 and 3 and 3 ways of slicing and dicing this rather tricky procedural question. So the fact that it's no longer what people have said for years, the Kennedy court, where lawyers would come to court prepared to argue to Justice Anthony Kennedy, because unless you got Kennedy, you weren't going to prevail. And now it's a challenge. I think it's going to be case by case. The justices in the middle, and I include the Chief Justice and Justice Brett Kavanaugh, and maybe Justice Barrett. We don't know yet. I mean, the court hasn't taken any public votes so far this term, so we don't quite know yet. It's really going to be very interesting, and I think pretty confusing to a lot of people too.
Did you see some of that last term, the ideological voting coalitions not staying true to what is sometimes predicted because of the political party of the president who appointed them? Did you see shifting starting last term?
What we saw last term, and I'm thinking of the big religion case called Fulton against City of Philadelphia, which was a challenge to the City of Philadelphia's insistence that all the social service agencies with which it had contracts had to abide by the city's non-discrimination policy, which included not to discriminate against same-sex couples. The church, the Catholic Social Service Agency that brought that case prevailed actually by a vote of 9-0. But the court was very splintered, and the conservatives on the court were splintered. So Justice Alito, who along with Justice Thomas and Justice Gorsuch, those are the three most conservative justices, wrote a very strong opinion saying we should have gone much further. And Justice Barrett, in an opinion joined by Justice Kavanaugh, said, no, actually, no, we shouldn't go further. We should rule modestly here because we're just not sure what we're going to do if we replace the current precedent with something else. So, at the end of the day, it's a 9-0 case. And a lot of people just kind of shrugged and said, well, it's a 9-0 case. But inside that case you could see something really interesting going on. I interpreted it a little differently than most people, I guess. I read Justice Barrett's very short concurring opinion as a message to Justice Alito saying, Sam, we're both conservative. We're both conservative Catholics. Hello, but don't take my vote for granted because it's not yours, it's my vote.
You talk about the orders the court issues, and usually, they're less than one page. But recently, you indicate that dissenting judges to the order are writing lengthy dissenting opinions, if you will. And why do you think that's happening more now than it has before?
I think what's happening again is this shadow docket issue. So the shadow docket used to be, there's always been a docket for emergency applications. Used to be kind of applying settled law, saying, okay, you've made a good case for our temporary intervention here, and we're going to grant a stay, we're going to grant a temporary injunction, we're going to decide whether we're going to hear your case, that kind of thing. But now that the court is actually making law in the shadow docket, as in the religion case, the COVID in-home worship case that I described, something substantive is going on. And so when it happens, even if the majority doesn't explain itself or explains itself only very cryptically, it gives occasion for those justices who don't agree to try to push back and say and call out for the public. Because one thing about the shadow docket is because there's no public argument session and there's no full briefing, and the court is fairly transparent. The court puts up all the briefs on its website, puts up the transcript of the arguments, puts up the audio of the arguments. So somebody that wants to tune into what is the Supreme Court actually doing can kind of sit in the comfort of their home and learn quite a bit. But on the shadow docket, where there's no argument and there's no full briefing, it has fallen in recent months to the dissenting justices to say to the public, okay, look, people, here's what just happened. And here's why we think that was a bad thing.
You indicated that Roberts held the center as the term came to an end, despite divisions of opinions on election cases and pandemic issues. But do you see that going forward? Do you see this term that he'll be able to hold the center?
Well, of course, that's the money question for this term. It really is. And I don't think we know the answer yet. I think a lot of the court's struggle in the last term had really been below the surface. For instance, the Mississippi abortion case that they're going to argue at the beginning of December, they have the state's petition pending on their docket for, I think it was 10 months. And they took it to their private closed door conference week after week after week to decide whether to grant the case. And they finally granted it. And that's why it's been fully briefed and it's going to be argued on December 1st. So, who held the balance of power there in terms of what to do with the Mississippi abortion case, the law that bans abortion after 15 weeks of pregnancy? We don't know. It only takes the votes of 4 justices to hear a case. It's a little deceptive to say that because, of course, often 4 don't want to vote to take a case unless they can count to 5, because why take a case that would make a national rule the wrong way? They need to know they're on the winning side, and something like that may have been going on with the abortion case. So, what the Chief Justice's role was in that, inside that black box of the closed door conference, we don't know. This term will really be perhaps the most telling term of the entirety of the Roberts Court.
I know you're going to continue to cover and watch the court this coming term. Can we expect a sequel?
Oh, I don't think so. I mean, somebody said to me, are you going to be like Theodore H. White, the making of the president in 1960, the making of the president in 1964? I said, I don't think so. I mean, I think the power of this book is that it tells the story of this highly unusual term. I mean, the death of Justice Ginsburg and the end of the Trump administration and how all that kind of meshed together with, really, you might say, President Trump's major legacy, 3 members of the Supreme Court of the United States. So certainly there'll be important things coming out of the court in coming years, but I don't envision a kind of a month-by-month chronicle, at least not by me, again in the future.
As we've seen throughout history, presidents who appoint members to the Supreme Court of the United States sometimes are displeased with how they vote because they don't necessarily agree with their votes. And as you indicated in the book, former President Trump publicly said he was ashamed of his appointees, that they were gutless. But you say, though, in fact, it was these appointees that saved the court.
What got Donald Trump so angry, and I quote really throughout the months following the election, whenever he was making a public appearance, he would find a way to denounce the Supreme Court, even though it had 3 of his people on the court. What made him so angry, of course, is the court did not do his bidding in his challenge to the results of the 2020 election. And he somehow assumed that they owed him, their assistance in challenging President Biden's victory. So what I meant was, had the court done Trump's bidding, the court would have been destroyed as an institution worthy of our respect. It would have destroyed its legitimacy had it become a tool for undermining the democratic process by which we elected, by a quite comfortable margin, a president of the United States.
Your inside perspective into the reasoning on why judges write what they do really impressed me. For example, you stated in the Trinity Lutheran case that came out of Missouri that the Chief Justice added a footnote, and here's how you phrased it. Probably it was a late addition to hold Kagan and Breyer. Now, should readers feel confident in the accuracy of your statement as to when that footnote was added and what the purpose behind it was?
I think so. I mean, to come out as I did with that conclusion, I really drew on my understanding of the dynamic of the court. I'm very confident of it, but maybe just so your listeners aren't totally baffled. So this was the case that was a challenge to the Missouri constitutional, the no aid provision. And Trinity Lutheran, a church, had a daycare center with a playground and wanted to apply for a state grant to improve their playground under this used tire program that the state has. And they were ruled ineligible to apply because they were a church. So that was the question. Now, and of course, this gets to something, very basic in terms of the separation of church and state. We've had decades and decades of struggle over the extent to which government can channel public money to parochial schools, right? This was not a parochial school as such, it was a daycare center. I think it's clear that the Chief Justice who wrote the opinion and said that the disqualification of the church from this program was an odious, he used the word odious, example of religious discrimination. If that conclusion had simply been left unadorned, it would have meant that states that choose not to use public money to subsidize parochial tuition and this kind of thing would have really kind of decided all those cases. And so he needed the votes of Justice Breyer and Justice Kagan. Justice Ginsburg and Justice Sotomayor were in dissent in that case. So how to assure them that they could sign on to this case and they weren't giving away the whole ball of wax. And so we put in this footnote saying, now this case is only dealing with playgrounds. It's not dealing with any other uses of public money for religious institutions. And Justice Gorsuch, who was brand new on the court at that time, I think he'd been on the court only for a month, he concurred in the bottom line of the opinion that the church was entitled to the program. But he said, we decide principles. We don't decide particular entitlements. And there's a principle here that goes way beyond playgrounds. So, wake up, people. So, that case, that issue came up again in the 2019 term, a case from Montana where the court opened the door even wider. And it's going to come up again in the current term. The court's agreed to decide a school case from the state of Maine that I think is really going to nail down. It's going to forget that footnote about it's only a playground was ever written, and is going to nail down the principle that if a state provides tuition assistance for any kind of schools, it has to include religious schools. This will be something that the Chief Justice has been driving toward for years. And I think I have no doubt that he's finally going to get what he wants in this case that's coming up this term.
The public regard for the court has been eroding recently. And I think in your book, you indicate it was down to 50% of public approval. And then more recently, I've read something where after the September 1 order on the Texas abortion case, it was down to 40%. Do you think the justices think about this?
I think some of them do. I don't think they're all on the same page as to how much they do or should care about that kind of thing. But I'd be really surprised if the Chief Justice is not attentive to it. I'm not saying he's going to, give up his principles to play to the public. I don't think that that's the case, but I think it's a matter of concern. And I think the court did take a big hit after September 1st, when, again, on the shadow docket, they allowed the Texas vigilante law to go into effect, that with the immediate effect of basically shutting down accessibility of abortion services in the second most populous state in the country, without giving people a chance to challenge this. I mean, you might say, how could this happen? I think the public was pretty surprised by that, as reflected in the polls. But political scientists will tell you that most people pay almost no attention to the Supreme Court most of the time. It's rare when the court kind of breaks through the public awareness, given everything else that people have to worry about. This was one of those times. How long that will last, what will happen if, in the Mississippi case, the court takes the occasion to shut down the right to abortion, or functionally so limited that it is as if they had overturned Roe against Wade. That's a question that we'll have to see. Will it mobilize people? And if so, what will people do? What option do people have? The justices have life tenure and there's no vacancy right now.
Thank you, Linda. I've enjoyed speaking with you and learning more about your knowledge and insights into our highest court in the country. As you say, it's an institution that maybe a lot of people don't know much about, but you have certainly opened the doors and rolled up the shades for us in your book. And I enjoyed reading. I enjoyed speaking with you today.
Thank you. The pleasure was mine, and thanks for guiding me in a real substantial conversation. Thanks a lot.